Please, Your Honor. I beg to mention item number 9, Your Honor. The conducting counsel is out of station.
You're appearing for?
For respondent number 4 and 5, Your Honor.
I'm for the petition, Lordship.
Any objection?
Your Lordship, I pray for 3 week times, Your Lordship. Yes.
On pre-made by the respondent 4 and 5 on the ground that the conducting counsel is indisposed, the prayer not being objected to by petitioner, matter is adjourned. List the matter up to 3 weeks as prayed for.
Objection.
Please, Your Lordship. Lordship, I beg to make a mention in item number 10.
You're for?
I'm for the petitioner, Your Lordship.
For the respondent number 2, 3 and 4.
I'm for respondent 1, Your Lordship.
That EPF matter
Yes.
Yes, Your Lordship.
on pre-made by the petitioner, list this matter for 2 weeks.
Oblige, Your Lordship.
Please, Your Lordship, I beg to mention item number 16.
You're for?
For the petitioner.
Yes, Mr. Sen.
No objection, Your Lordship.
Nothing has come out of the settlement?
No, nothing so far.
Nothing so far or nothing at all?
I'm hoping that there will be some sort of a settlement in the future, but at the moment, nothing as yet.
On pre-made by the petitioner, list this matter after 3 weeks.
Oblige.
Please, Your Lordship, I beg to mention item number 17.
You're for?
For the petitioner, Your Lordship.
On pre-made by the petitioner, list this matter after 3 weeks.
Oblige, Your Lordship.
Please, my Lord, may I be permitted to make a mention of item number 14? The conducting counsel, Mr. Argurong, has some personal difficulties.
Please, Your Lordship. Lordship, this matter hearing has been concluded and we are directed to file our written argument. So it's a joint request from both the parties that further 1 week time may be granted to file our written argument.
I'll give you 2 weeks, fine.
Right, my Lord.
On pre-made with parties seeking time to file their respective written argument. Excuse me. List this matter after 2 weeks.
Daily cost list item number 1. Your Lordship, we have already filed an affidavit.
Affidavit of service.
Your Lordship, we have already filed an affidavit to bring on record the service of notice upon the respondent number 2, Your Lordship.
Respondent 2.
It has already been delivered.
Anybody appearing for respondent 2?
Your Lordship, item number 2 till 6 is a connected matter.
Who's respondent number 2?
The informant, Your Lordship.
What is this case about?
For questioning the FIR, Your Lordship.
In fact, Your Lordship, the name should not have been reflected, but
That's what I was wondering.
this is the victim, Your Lordship.
Victim is she's a minor.
Your Lordship,
Your Lordship, actually the senior conducting counsel is not available due to some personal difficulties, not here. So I pray that the matter may come up after 2 weeks, Your Lordship.
Well, first you check, you see, if the victim, if the respondent 2 is a minor, then it would not be proper for the name to be reflected.
Your Lordship, she's not a minor anymore. Not a minor.
She's not a minor, Your Lordship.
Anymore, or at the inception of the matter? Even at the inception, she was not a minor.
Your Lordship, pardon.
Inception of the inception of the case, was she a minor or not?
She was not, Your Lordship.
She was not.
She's not.
On premier by the petitioner, the heard learned counsel for the petitioner was submitted that the notice on respondent number 2 has been affected, and 2 days extent an affidavit of service has been filed. However, the respondent number 2 is yet to make her appearance before this court. On pre-made by the petitioner, this is matter of 3 weeks to let the respondent 2 appear before this court.
Oblige, Your Lord. 4 to 6, Your Lordship.
4 to 6.
Oblige.
Same order.
Item number 7.
Yes, now who's appearing for respondent 7?
Respondent Swear opinion. I appeal for the state, but senior counsel is for the district council.
Yeah, but respondent 7 is the Darbashno.
Yes, Your Lordship.
Please. I think they are not.
We are waiting only for the respondent 7 to.
Yes, madam. Because of the withdrawal of the RTA council.
Yes, yes. Earlier counsel or Miss Shila, have you taken steps for issue of notice? Fresh notice has been issued.
Yes, Your Lordship. We have
Any-
also filed affidavit of service, Your Lordship.
Affidavit of service.
Yes, Your Lordship.
Registered post people?
I tried to inquire internally, indirectly. They have no idea about the council having left them, nor they have received anything. I mean, because they happen to be neighbors.
Yes, in fact, if any party is is at liberty to inform them. They should be informed, either by the petitioner or by anybody for that matter.
They don't know. That's the thing.
didn't keep it here. Keep it.
You have it, so
Looking for the next one. It should be in the
you don't need that. We can have talking.
No. It's the only. Many people. Days.
Yes, Mr. Kanta, the postal receipt
Yes, shows that
it would indicate that
received.
it has been received.
In that case, my lord.
Are they a necessary party?
They are, my lord, because
They are the main party. Main party.
my lord may allow us to file dusty to take dusty service also on them.
Will be better, you know.
Why I'm saying this is because, my lord, sometimes my lord, the postal receipts, I mean the postal status
Received by someone
quite
else.
deceiving, my lord, because we really don't know who has received it. The person who is supposed to receive might not have received and somebody else might have received, but the postal status would
Is
in
a
any
postal.
case show that it has been
Will be
delivered.
dusty service.
That's why, to be in all fairness, my lord, we'll take dusty service again.
Again, Mr. Thapa, we were discussing this issue time and again. What do you mean by dusty service?
Hand.
By hand.
Is it there in the rules?
It is, I think it was there in the
Previously, it was there in the
Guwahati High Court rules.
What about our rules?
Dusty service is accepted.
It's both Urdu and Arabic. I was discussing this with someone also. Dusty means by hand. Even Wakalatnama is not a.
Whatever, see, whatever
Talabana also might be filed. Talabana, this is not part.
no, whatever the connotation or the the term as such, the process, whether it is it is there in the rules.
Yeah, there is an accepted.
If it is, it may be accepted, but if it is not officially indicated, then how do we see what you will say that the recipient may not, he may come and say I may have acknowledged, but it's not there. Officially, I have not done so. What do we do? Perhaps in this case, it may not be.
Personal.
Some sensitive cases might happen. So we have to, let's say, legalize it.
We can avoid that term, let them serve personally on the respondent number 7. Maybe in a very speaking manner.
Mr. Estapa, counsel for the petitioner, has submitted that the notice upon the respondent number 7 has been issued, and to this and in this regard, an affidavit of service has been filed, annexing therein a copy of the track consignment issued by the brought out by the postal department through its portal to indicate that the said notice has been duly delivered to the Dorbarshnov Rinja, that is the respondent number 7. The same said to have been delivered on 25/5/2023. However, in all fairness, Mr. Thapa has submitted that the petitioner may be allowed to take further steps by an alternate method of service, that is by delivery personally to the concerned official of the respondent number 7, and to file a further affidavit of service in this regard. On pre-made, the same is allowed. Let steps be taken accordingly. This is matter of 2 weeks.
Item number 8.
This matter, my lord.
Sorry.
I've seen the last order, my lord. In fact, the lordship had categorically indicated that there would be no further adjournments in this matter. But here, my lord, Mr. Paul was supposed to appear through VC in the morning. In fact, this is what we had discussed in the morning, that he would be appearing. But it seems, my lord, he's not there. Seems because the matter seems to have collided, my lord, perhaps.
What
he's
collided?
required in the Supreme Court also, my lord. That is why he's still in Delhi. He had some matters today, that is what I'm told. My lord, kindly have this matter, my lord, expressing my difficulty with the deepest of regret, my lord. Kindly have this matter next week, my lord. He will be physically present. My lord, I have nothing to say, my lord, given the fact that in earlier order, my lord, it was very categorically indicated.
If he is supposed to be elsewhere, not necessarily Supreme Court or anybody, any place for that matter, which is not an excuse in any case.
Correct, my lord.
He should have made an alternative arrangement.
He was
You are there.
in the morning. We had, in fact, we were told, my lord, we were told by him that he'll be there via VC, my lord.
If I'm not mistaken, this matter has been substantially heard. Of course, the only thing now is the time has passed by for us to really recall.
There was a lot
what
of
was said,
things happened in between.
Submitted.
We were supposed to examine records, could not be examined.
Yeah, I think the last time around it was only for inspection of the relevant records.
Correct, my lord.
And for the private party to just give some clarification.
Which, if I recall correctly, Mr. Khan has also taken his time there. Anyway.
Well, I'm only seeking a limited.
May I make a submission? Lordship, I have some document obtained from public domain, which is necessary for this case. I have already made compilation of it. And there's certain question of law which has already been decided by the Supreme Court in 1989 with respect to the entire matter which the case is in subject matter with. So, Lordship, may I submit in advance, Your Lordship, the copy?
Well, he can bring on record, Lordship, by filing an affidavit in case.
Have you filed your affidavit?
I have filed, Your Lordship. 2019, month of July.
Are these?
No, Your Lordship, I have prayed before Your Lordship to place these documents.
Yes, so these documents, are they required to be brought on record?
Yes, Your Lordship.
Then he needs leave of the court and.
Then you have to do it by way of affidavit, so that you can, give them a chance to file a rejoinder.
Yes, Lordship. The matter that and the document which I'm relying upon, Your Lordship, it's a matter connected with the annexure which I'm relying, which I have relied upon in my affidavit. So it's important for adjudication of the matter on merit as well. And it will help the cause a lot.
Okay. So we'll take it that you are filing additional documents.
Absolutely.
Letter counsel for the respondent number 4 has submitted that even though the respondent number 4 has filed, you are
As Arlington.
no, you are whom?
Presbyterian Church.
Presbyterian Church.
As respondent 4 has filed its affidavit, counter affidavit. However, in course of these proceedings, the respondent 4 has come across certain documents or papers which are relevant to its case as far as these proceedings are concerned, and for which, even though it may be at a belated stage, prayer is made for the same to be brought on record by way of an affidavit. Councils across the board has no objection to the prayer made, and has also prayed that they may be allowed to file any rejoinder if so required, if so advised, on consideration made, even though this court has indicated that this matter has to be heard finally in view of the development put forth. The prayer of the respondent 4 is allowed. Let the affidavit be filed within 1 week. This is matter.
1 week. What we could do?
This is matter to 1 week. This is matter thereafter.
Item number 11.
Lordship, we have served the notice to respondent number 4, Lordship, but service report are still awaiting.
Why respondent 4?
They are also the party, Lordship.
And a counsel for the petitioner has submitted that the respondent number, the notice on respondent number 4 has not yet been confirmed whether it has been received or not. It is prayed that some more time may be awaited. Pray aloud. This is matter for 2 weeks.
Obligation, Lordship.
Item number 12.
But this matter, I have received some instructions, madam. So I'll pray for some time, madam, to file an affidavit.
What are your instructions?
Madam, this matter, when this matter was taken up,
This is with regard to that regularization?
That compassionate appointment.
Oh, compassionate appointment.
Yes, yes. My lord, because our stand is that her appointment is not as per the rule.
Yes, yes, yes.
My lord, and in the process of the argument, my lord, there was a query from this honorable court with regard to promotions, my lord. So that instruction I have received, my lord. So I may be allowed to place it on record by way of an affidavit.
Mr. KP Bhattacharya, led GA, appearing for the state respondent, has submitted that there are instructions received from the concerned department concerning the issue raised in this petition, and prayer is made that the same may be allowed to be brought on record by way of an additional affidavit. When prayer made, the same is allowed. Let the said affidavit be filed within the next date fix. This is matter after 2 weeks.
Item number 13.
Please, Your Lordship.
Do any of you watch the recording after the live streaming is over? I mean the proceedings is over?
Sometimes.
If you watch the recording, please ignore my coughing. Becoming too embarrassing at times.
But if we watch ourselves, it's very embarrassing. So I prefer not to watch one.
It appears so.
Lordship, item number 13 and 15 are connected. May I pray that Lordship will first take up item number 15. This is a shorter matter in my understanding.
No, these are the archery matters, Madam. We filed a suit before the trial court and against various orders they've come before this honorable court, Madam.
Yes.
Now, in this matter, my lords, this pertains to an injunction order which was obtained by the respondents. We are aggrieved with that. We filed a revision application. Now, this matter was heard by Lordships on a prior occasion where the respondents had raised objections with regard to the maintainability of my petition. There were 3 objections which were raised. Number 1, that because I have not added the other parties which were originally arrayed in the main petition, so therefore there is a difficulty in entertaining this application. Number 2, there is a delay in filing this application, so the law of limitation will act as a bar. And the third is that my remedy is not before this honorable court by way of a revision. My remedy is by way of a statutory appeal before the appellate court. Those were the 3 objections. I'll just deal with the first objection. They have placed reliance on 2 decisions, one from the Madhya Pradesh High Court and one from the Punjab High Court. Now, this basically states that under Order 41 Rule 20, if a party who has originally been arrayed as a party in the main suit is not arrayed as a party before the appellate court, and if he is interested in the outcome of the appeal, then the court may make him a party. Court will not find that the appeal is incompetent and dismiss it straight away. But if the court finds, and the test is if they are interested in the outcome of the appeal, then the court will make them a party. And for that purpose, the matter will be adjourned to such date.
How do we come to that determination?
My lords, if at all the appeal is allowed in my favor, the question is, would it affect the private parties, the other parties who are parties to that? May I, Lordship, for that purpose, give a Lordship a brief factual background. Lordships will be able to appreciate the whole matter. So sometime in 2016,
yes,
the entire genesis of this matter is in 2016. The respondents are engaged in the business of arrow shooting with several other organizations who are also party in the main suit. Yes. Now,
please.
A dispute broke out between these parties. It escalated to a point that it reached the office of the state respondents. The state respondents considered the matter and directed the respondents to restore the suspension order which was issued in favor of the private respondents. They were aggrieved by the interference of the state. They approached this honorable court by way of a writ petition. The learned single judge did not entertain the writ petition and dismissed it. Aggrieved with that order, they approached the division bench of this honorable court by way of a writ appeal. Now, even the division bench of this honorable court was disinclined to entertain the appeal, at which point they prayed that they may be allowed to withdraw from the entire writ proceedings. That is the writ appeal as well as the original writ petition. And they further prayed that they may be given the opportunity to explore other remedies, including, and this is important, including approaching the commissioner, that is the state respondents, by way of a representation. Now, this prayer was considered by the court and allowed. So as a result, the entire writ proceedings were closed and they were given the opportunity to explore other remedies, including approaching the state respondents. Now, pursuant to that, they filed a representation before the state respondents. The state respondents kept that pending for some time and eventually sometime in 2020 rejected the representation and basically reiterated their stand taken in the order of 2016, which was that you revert back to the original position and ensure that every other organizer is brought back to the original position. Nobody should be suspended. Aggrieved by that, they again approached this honorable court by way of a writ petition. That writ petition was being heard. They realized the court was not inclined to entertain it. They withdrew from this with liberty to approach any other, take recourse to some other remedy. Pursuant to that, they filed a suit challenging the order of 2016 and subsequently all other orders which were basically reiterations of the original order of 2016 and obtained a status quo order. Now, that status quo order was for the limited purpose that the order of 2016 issued by the state respondents should not be given effect and the suspension would remain and the respondents would continue to operate the game of arrow shooting. Now, while that was the position, the state respondents found that the license under which they were operating, that had expired and there was no renewal. So, show cause notice was issued. And finally, they were told that they can't operate it because the license had expired. Now, this, in my understanding, was a completely separate issue. This was not connected to the main suit or any orders of stay issued by the learned trial court. Aggrieved by that, they approached the learned trial court by way of an application for stay. We opposed that, and our main contention was that that was a completely new cause of action. It was a subsequent event. It was not related to the issues in the main suit. The trial court heard the matter and confirmed the stay order. Aggrieved by that, we are before this honorable court. So now, if lordships have noticed that the subject matter of that second miss case was only in relation to their license and the termination of the license. Now, assuming for a moment the courts find that the license has expired and they're not entitled to any sort of stay or any protection from this honorable court, that will only affect the respondents and it will not affect anybody else. So I believe I would have qualified the test. So Order 41, Rule 20 will have no bearing here.
So
that is the first issue.
So in that case, there is no requirement for you to re-ID other respondents.
I believe so,
other parties.
That is my humble submission, my lords. Because the test under Rule 20 is that the other parties who are non-parties, who have not been arraigned, they must be interested in the outcome of the appeal. So if lordships find that my appeal can be sustained and I have merit in my appeal and set aside the injunction order granted by the learned trial court, this will not affect the other private parties.
That is logical.
So that is my submission.
The issue is with regard to the termination of the license.
Yes, and it is only limited to them. So it is interstate the State Department and the respondents. None of the other parties in the main suit have any sort of participation in that, or any they would have none of their rights would be affected by any orders passed in relation to that particular license. Now, they had placed reliance on two decisions. May I just take lordships to the first decision? This is a judgment of the Punjab High Court.
Punjab?
The decision dated 28th of January 1959. The name of the parties.
Where is the citation for this?
They had supplied copies of this on the last hearing, Lords.
This is not reported case.
No, it is a reported case, Lords. This is a citation from SCC.
From SCC.
Notified Area Committee Burai versus Govind Ram and others.
Yes. You have not given me the citation, Dr. Musika.
Your lordships will have a copy of the judgment.
Copy, yes, but
my lord, this is from ILR, my lord. On the top, lord, this is true print source, ILR, Punjab and Haryana.
But there must be a correct citation given.
Reported in SCC, I believe. Perhaps this is not reported in SCC.
This is a High Court decision.
This is the High Court decision, not reported in any of the other journals.
Either IRR or the local journals or even AIR.
That's what maybe it's not been reported in any of the journals. I'm not really sure.
What the citation will be ILR volume 12. I'll get the.
That's what is required.
It is there, my lord. Volume 12, page number 1066.
What is it?
Because old decision, maybe the pattern was different that time. But 1066 is mentioned here and volume 12.
Where is it?
On the top, Punjab series, then
Punjab.
1066.
I've seen.
So it is, precisely. It does mention ILR, volume 12, and then the page number would be the first page, 1066.
I'll get this exact citation, how it's written.
If your lordships turn to the next page, the second page of the judgment, on the top, lordships will find it mentions ILR, Indian Law Reports.
Yes, I think you're correct. It's ILR, volume 12 and 1066. Please.
So this was a decision relied upon by the respondents.
Yes.
In support of their contention that since some of the other respondents who are parties to the original suit and the original application have not been made parties in my revision application, my application is incompetent. Now, this was a decision of the full bench of the concerned court in relation to a reference which was made. I'll take your lordship through the facts. I'll just provide a concise of the facts in this particular case. Well, a suit was filed by 6 plaintiffs in this particular case, and the suit was decreed in favor of the plaintiffs. A first appeal was filed by the respondents, which was dismissed. But while dismissing the appeal, one of the names of the plaintiffs was omitted by the court in passing the judgment. So thereafter, when a second appeal was preferred, so second appeal was filed in the name of 5 plaintiffs, omitting the name of one of the original plaintiffs, on account of the fact that the first appellate court left out the name of one of the parties in its own judgment. Taking this as a ground, the respondents contended that the second appeal was not maintainable. As a result, a reference was made that this was covered by Order 41, Rule 20, and as such should be dismissed. After examining the matter, the learned High Court, the Honorable High Court, rendered its decision in the second last page, my lords, page 1110.
Yes.
May I read the last paragraph, my lords?
Yes.
I would therefore answer the question referred to us as follows, that if a party to the original proceedings is not impleaded in appeal on account of a bona fide and honest mistake on the part of the appellant, the appellate court has ample powers under Order 41 Rule 20 CPC to allow the mistake to be rectified and the party to be added. Because here, my lords, it was not intentional on the part of the appellants to omit the name of one of the plaintiffs. It was on account of the fact that the appellate court in its judgment had inadvertently omitted the names of one of the plaintiffs. The second reads that section.
But the plaintiff in the first appellate court was, was there in the array of parties.
Yes, they were arrayed in the main memo of appeal apparently, but in the judgment, the court had made some sort of an error. Inadvertently, one of their names was left out. So when they preferred the second appeal, inadvertently they copied the array of parties from the judgment, and as a result, they left out one of the parties.
Understandable.
Lordship. That section 1072 read with Order 1 Rule 10 CPC enables the appellate court to add parties in appeals in suitable cases, but this power must be exercised within the period of limitation. And 3, that apart from the provisions of Order 41 Rule 20 CPC, the appellate court has inherent powers to permit parties to be added to appeals in suitable cases, and the language or rule 20 of Order 41 is not exclusive or exhaustive so as to deprive the appellate court of the inherent powers in this respect. I would humbly submit, my lords, this particular case with its facts has no application to my case. The second judgment, which they refer to, is from the Honorable Rajasthan High Court. And the citation is 2012 SCC Online Raj 652.
Yes.
Let's kindly turn to page 3, para 7.
Yes.
May I read, my lords? At the outset, it is required to be noted that though the appellant plaintiff has filed the suit against the present respondent and 3 others, the present appeal is filed only against the respondent JDA original defendant number 1 without joining the other defendants, that is defendants number 2 to 4 as party respondents in the present appeal. On the query put by the court, the learned counsel so-and-so submitted that since the injunction was sought only against the respondent defendant number 1, other defendants were not joined as party respondents in the present appeal. The said submission of Mr. So-and-so is not acceptable for the simple reason that the appellant plaintiff, having filed the suit for declaration and permanent injunction against all the defendants would be necessary as well as proper parties in TI applications as well as in the present appeal arising out of the order passed in TI application. The present appeal, therefore, is held to be bad by non-jointer of necessary parties. Now, in my respectful submission, my lords, here the court holds, and that is not the ground on which the appeal was dismissed, but this is an observation passed by the learned court, that if the parties who were originally arrayed in the main suit and the original proceedings are not made parties in the subsequent appeal or revision, then that particular appeal or revision is not competent. Now, this goes against the law of Order 41 Rule 20, which provides that in case the court finds so, court will have to apply the test to see whether the party who's been left out is somehow aggrieved or interested in the outcome of the appeal. So Order 41 Rule 20 was not examined by the learned court, most respectfully, my lords, and this order was passed. This also contradicts the law that has been laid down by the full bench of the Punjab High Court, in my respectful submission, my lords. Now, in support of my case, I would rely on a few judgments. The first is 1990 Supplement SEC 801. आपको कॉपी दे रहा हूँ. 1990 Supplement SEC 801.
Then what we can do is, can you continue in the next half?
Lordship. What is praying, madam? Mr. Sen will complete his part, madam. I'll respond after a few days. Any day, madam. But today I couldn't go through this file. We will continue tomorrow.
Would Lordships consider having it tomorrow then?
Tomorrow I think we have quite a number of cases. Okay, we'll try and see tomorrow.
Tomorrow, day after tomorrow, any time.
Lordships, day after is, I'm informed, the coal matters and the full bench matters are there. Time may not permit. So we will just make an attempt tomorrow.
Heard the counsel petitioner. However, on premium, the matter will continue for the hearing on 12. We'll continue tomorrow. List the matter. I've noticed that councils are very reluctant to take the matter after lunch either.
No, I'm ready to do it.
In fact, after lunch you have more, because there'll be only very few matters left, 1 or 2. So we could concentrate and finish it off. Fine.
Good.